Hello students, today we will be talking about protection of child rights under the international law. Now let me give you a brief introduction as to what is it about. The international laws for protection of rights of children comprises various treaties adopted from time to time amongst the international communities. It was not until the late 19th century that nascent children's rights protection movement countered the widely held view that children were merely quasi-property and economic assets. A push for children's rights occurred in the 1960s and 70s when children were viewed by some advocates as victims of discrimination or as an oppressed group. In the international context, the growth of children's rights in international and transnational law has been identified as a striking change in the post-war legal landscape. Some of the important international treaties and conventions regarding protection of the rights of children, some of them I will tell you just now. Universal Declaration of Human Rights 1948, which is called UDHR. The UN General Assembly adopted the Universal Declaration of Human Rights on 10th December 1948. The declaration was the first international basic document on human rights dealing with the inalienable and inviolable rights and freedoms for all members of the human family, which provides that everyone is entitled to all rights and freedoms set forth in the declaration without distinction of any kind, such as sex, caste, race and status, amongst others. It consists of a comprehensive set of human rights and freedom of individual comprising of both civil, political and socio-economic rights. Now, though the declaration is not a legally binding global document on human rights, it is intended to serve as a universally accepted common standard of achievement for all people and all nations. Now, even in the context of protection of child rights, the declaration provides two special provisions. Article 25(2) provides that motherhood and childhood are entitled to special care and assistance. All children, whether born in or out of wedlock, shall enjoy the same social protection. Article 26 calls for the right to education for all and deals with both with access to and the aims of education. Thus, education is to be free, at least in the elementary and fundamental stages. Elementary education is to be compulsory and education should be directed to the full development of the human personality and to the strengthening of respect for human rights and fundamental freedoms. Therefore, it is a fact that every child as a human being, he or she is entitled to enjoy all rights and freedoms accorded in the declaration. International Covenant on Economic, Social and Cultural Rights of the year 1966. Specific references to children are found in Articles 10 and 12 of the International Covenant on Economic, Social and Cultural Rights, which in short is called ICESCR. Under Article 10, the widest possible protection and assistance should be accorded to the family, particularly for its establishment and while it is responsible for the care and education of dependent children. It further stipulates that special measures of protection and assistance should be taken on behalf of the young without any discrimination, that they should be protected from the economic and social exploitation, that employing them in morally or medically harmful or dangerous work or in work likely to hamper their normal development should be punishable by law, and that age limits should be set below which the paid employment of child labour is prohibited and punishable by law. Now, the ICESCR also provides for the rights of everyone to education and stipulates primary education shall be compulsory and available free to all. International Covenant of Civil and Political Rights, 1966. In this Article 2 of the International Covenant of Civil and Political Rights obliges state parties to respect and to ensure to all individuals within its territory and subject to its jurisdiction the rights recognized in the ICCPR without distinction of any kind. To adopt laws to give effect to those rights and to provide effective remedies where there are violations. Article 14, Clause 1 incorporates a more specific reference to rights of the young. Any judgment rendered in a criminal case or in a suit at law shall be made public except where the interest of juvenile persons otherwise requires or the proceedings concern matrimonial disputes or the guardianship of children. Furthermore, criminal proceedings should take account of juveniles' age and the desirability of promoting their rehabilitation under Article 14, Clause 4, and the penal system should segregate juvenile offenders from adults and accord them treatment appropriate to their age and legal status. This is cited in Article 10, Clause 3. If a marriage is dissolved, provision must be made for the protection of any children. Article 23, Clause 4. Article 24 of the ICCPR is specifically devoted to children. It stipulates that every child shall have, without any discrimination, the right to such measure of protection as are required by his status as minor on the part of his family, society and the state. It further prescribes that every child must be registered immediately after birth and have a name, and that every child has the right to acquire a nationality. UN Convention on the Rights of the Child, 1989. The United Nations General Assembly adopted the Declaration of the Rights of the Child in 1959, which was the expression of international concern, particularly for the protection of rights of child. One of the key principles of the declaration was to provide special safeguards, opportunities and facilities for the child. Even though the declaration was a comprehensive global document on the rights of the child, it was not a binding document. Therefore, the United Nations adopted the Convention on the Rights of the Child in 1989 as a legally binding document. The Convention on the Rights of the Child, which is called CRC, is the most comprehensive international document on the rights of children. Now, the CRC is primarily concerned with 4 aspects of children's right. This is called the 4 Ps. Participation by children in decision affecting them, protection of children against discrimination and all forms of neglect and exploitation, prevention of harm to them, and provision of assistance to children for their basic needs. For the purpose of the CRC, a child is defined as every human being below the age of 18 years, unless under the law applicable to the child, majority is attained earlier, according to Article 1. The CRC creates new rights for children under international law that previously had not existed, such as the child's right to preserve his or her identity, Article 7 and 8. The rights of vulnerable children like refugees to special protection, Article 20 and 22. And indigenous children's rights to practice their culture, Article 8 and 30. In some instances, this innovation takes the form of child-specific versions of existing rights, such as those in regard to freedom of expression, Article 13, and the right to a fair trial, Article 40. In addition, the CRC enshrines in a global treaty rights that hitherto had only been found in case laws under regional human rights treaties. Now, the example is children's right to be heard in proceedings that affect them, Article 12. CRC also replaced non-binding recommendation with binding standards. For example, safeguards in adoption procedures and with regard to the rights of disabled children, Article 21 and 23. New obligations are imposed on state parties in regard to the protection of children. In these areas, such as banning traditional practices prejudicial to children's health and offering rehabilitative measures for victims of neglect, abuse and exploitation, which are under Article 28, Clause 3 and Article 39. Finally, the CRC sets forth an express ground obligating state parties not to discriminate against children's enjoyment of CRC rights. Optional protocols to the CRC on sex trafficking and armed conflict. The UN adopted 2 protocols to CRC on May 25, 2000. Number 1 is the optional protocol to the CRC on the sale of children, child prostitution and child pornography 2000, which is also called sex trafficking protocol. And number 2 is the optional protocol to the Convention on the Rights of the Child on the involvement of children in armed conflict, which is also called Child Soldiers Protocol. Now, the Sex Trafficking Protocol, which is called STP, addresses the problem of sex trafficking. The sex trafficking defines or the STP defines and prohibits the sale of children, child prostitution and child pornography, obliges state parties to make certain acts punishable under the criminal law, sets forth the basis for state parties to assert jurisdiction over actionable practices, and strengthens their ability to pursue extradition of offenders. Now, the Child Soldiers Protocol increases the minimum age requirement for direct participation in armed conflict and conscription to 18 under Article 1 and 2 respectively, and forbids rebels or other non-governmental armed forces under any circumstances to recruit or to use in hostilities persons under that age, which is stated in Article 4. It also requires state parties to take all feasible measures to ensure the demobilization or release from service of children recruited into armed conflict or used in hostilities, and when necessary to accord all appropriate assistance for the children's rehabilitation and social reintegration. This is stated in Article 6, Clause 1 and 3. Other international conventions. There are few international human rights treaties which have also focused on protection of right. For instance, the Geneva Convention of 1949, along with the 2 additional protocols of 1977, aim to protect the rights of the child, especially during the war and armed conflict. The Convention on Elimination of Discrimination Against Women, 1979, which is also called CEDAW, refers to the interest of the children being paramount in relation to the common responsibility of men and women for their children's upbringing and development. You can see Article 5, Clause B, as well as in regard to the state parties ensuring the same rights and responsibilities between men and women as parents in matters related to their children, especially in matters of guardianship, wardship, trusteeship and adoption of children. Article 16, Clause 1, D and F. The CEDAW prescribes betrothal and marriage of children and also calls for action to specify a minimum age for marriage and to make sure that marriage is registered compulsorily. Article 16, Clause 2. Now, in addition, the series of Hague Conventions adopted by UN, the Hague Convention on Jurisdiction relating to Adoptions, 1965. The Hague Conventions on the Civil Aspects of International Child Abduction, 1980. The Hague Conventions on the Protection of Children in Inter-Country Adoption, 1993. The Hague Convention on Jurisdiction for the Protection of Children, 1996, and the Worst Form of Child Labour Convention, 1999, have also highlighted the significance of protecting the rights of children in different circumstances. Therefore, the protection of rights of child available under the various multilateral international treaties and agreements has also been found an important concern for the global community. The international community under the aegis of United Nations is making every effort to protect the right of children by eradicating child labor, trafficking for prostitution, exploitation of every form, and provide a minimum standard for protection of the rights of children by obligating signatory states to enact laws, that's important, for protection of children's rights where the paramount consideration is the best interest of the child. With that, we conclude today's class. Thank you very much.